take a little time here to go through in kind of an outline form, very general, the steps you have to go through, and maybe some tips along the way to get an application in for Social Security Disability or SSI. Most of them are the same, and you only do it once, and we would apply for either one. There might be a couple deviations from that. But so the first thing is getting the application in, right? Technically, there's a multitude of ways to do that. We have our call in and make a phone appointment. They're probably going to, even if you walked in, they probably don't have the time. No one's carved out a big blank hour or two for you if you just walk in to take all your information to file the application. So if you do walk in and say you want to file, they will probably set up an appointment. And then you can either do it in person, or it could be that they say, hey, let's do it over the phone. So that's one way. I don't prefer it, but that's one way. The other way is online. I think that's the way they might prefer. Now, if you're doing SSI, you might not be able to do that at this point. But if it's Social Security Disability, and if you don't know the difference, and it's very important to know, please check out the video on the differences, because you need to know so you don't blow it and file for the wrong thing and screw yourself over. Okay, so online, ssa.gov, you can apply. I will say that if you do it online, which is their preferred way, you are going to want to have with you the basic information of your identity. You probably already have that. You know when you were born, you know your Social Security number. If you are naturalized, you weren't born here as a citizen, but became a citizen later, or are otherwise here legitimately, you're going to have to go through a few more steps, because you're going to have to produce naturalization papers and such. And you're going to want to have that date of naturalization when you do that online application, or if you're going to speak to them and do a phone application or in person, because that's one of the initial steps in the very beginning. Okay, so have that in advance. You're also going to want to have all of your treating medical providers now, and any that were recently enough to be relevant. So in my opinion, if they had to do with the current problem you have now, let's say you had surgery 2 years ago, went back to work, but then that body part you had the surgery on ultimately didn't succeed, and you had to stop work. That surgery, even though it's a couple of years ago and you weren't legally disabled at that time, even despite the surgery, that could be really relevant. So I would include that. Now, if you're applying with the assistance of an SSA field office staffer, they might refuse to take that information, saying it happened too long ago. It's one of the reasons why I don't like it when you go directly through a staffer and have them decide what questions that you're going to answer. Ideally, honestly, you're going through an attorney or a non-attorney rep who's doing all this for you after you provide them the data that they're going to need on their own way of gathering that from you. I know with us, I get it on paper from you in a very staggered format, so it's not overwhelming. And then we do our little maneuverings with it. So it gives you kind of time to sit and think. And some people do a page a day. Some people do bang out the whole thing in a day. Everyone's so different, but at least it gives everyone the opportunity to go at their own pace. Okay, so when you have all this information, you know your doctor, you have all their business cards, or maybe you have that walkout paper that they usually send you home with. You know every doctor, address, phone number. If it's with me, I want the fax, but their form isn't going to require that. But you get better results when you have the fax. You're going to want all that. So when you start the application, you get yourself identified. The SSA system recognizes you as someone who's can file, which means generally that you have a Social Security number and meet other minimum criteria for getting past that step. Then they will take some of that information, where you last worked, if you're married, if you have kids that are minors, things like that. And then you submit at that point what is like the beginning of the application, but it's then going to pop you into what is the medical portion, and that's where all the doctor information is coming. Early on in the process of this time you're on, first time, you will get a reentry number after a couple minutes of putting in information, just some of the very basic information. That means they've connected you to their system, and that's good. You're going to record that reentry number, print it out, save it to your computer, whatever you're going to do. And that is good for two reasons. The first is that if you're tired and you don't want to finish it all in one setting, you can come back to it. You have that reentry number. Now for a Title II, which is Social Security Disability, that reentry number, which also constitutes a contact and therefore a protective filing date. So in case you take a few months to get it all in, you could still say you filed back in April or whenever. So that number will help you get in for the next 6 months. If you don't get your application fully in and signed, because they might want you to sign something after that they mail to you. So I wouldn't wait on 6 months. I'd go 5 months. If you get that all done, that date you started and got that reentry number is going to be most likely your protective filing date. There are exceptions to that too, that can actually bring it back further, but that would be the general. The other good thing about the reentry number is that you have that protective filing, and that is going to protect any loss of benefits that would otherwise have occurred if you didn't have it. And that can happen if you waited a while to file. Let's say you, from what could be your onset date, your alleged onset date, which is a term of art, and you really need to know about what it can be. Don't just assume it's the last day you worked. It might actually be before then. But it will help ensure that you can get back benefits. And they won't scroll off the board if you wait, say, more than 17 months after what would be the appropriate alleged onset date. More than 17 months, you're never going to get any, you're never going to get those oldest months. They're going to start scrolling off 1 month at a time and not be available for you in retroactive back benefits. So that protective filing is very important. Once you get that protective filing reentry number and you saved it, right? And there's even a part in there where they say, do you want us to email this to you? And you should say, yes, you do. Then at least you know you also have it in the email. But I would still save it. I would still write it down, have backups. You know how technology tends to screw up. So once you get everything in, and it says, and by the way, I would print any kind of confirmation page you have that it's not submitted yet, or it is submitted yet, or ever, just print it out. And while we're at it, you should be keeping a file or a box, if you're not quite into the filing thing, where you put such papers in. You're going to want to put that in when you get to the end of that, and you can print out, it gives you a review summary before you submit any particular important section of something. Print it so you know what you put in there, because sometimes it's very easy to get confused on questions, and you might be saying something different later, and then it's going to contradict. So, and plus you just want to have it. So print it, put it in your box. Or if you have you know how to use technology and can print it to a PDF and save it to a safe place on your computer, hard device, cloud, wherever, that's fine too. Or do both, depends how careful you want to be. And then once it is fully in and done, and it's a done deal, you are now applied. They might be sending you a document that's a printout of your answers, and they want you to go through and correct any changes and initial them if something is erroneous. And they want you to sign the signature page that they have attached. They might also be including there an authorization to release medical information. That's the SSA 827. You would sign that. You would do the corrections and sign the application printout. They might be sending you an SSA 8240. That's, they want authorization to contact employer if they need to. They don't actually tend to do that much, but you just want to sign whatever they ask you to sign and send it back. And I would send, if anything like that is requested of you, send it certified return receipt requested or UPS. Don't send it regular mail. I can't tell you how many times it's lost. And I don't know if it's lost by the USPS or it's lost once it gets there. But if you don't have proof that you got it to them, and that 6 months, maybe you had to get the application in within 6 months after you started that process to keep that old application date, it's like it didn't happen. And now you potentially lost those back months of benefits that I was talking about. So please Anything you mail to the SSA costs more, but I would send it certified mail, return receipt requested, which is USPS, but you have to go there in person, fill out the card, and they help you stick everything on. So if it's USPS that way, that's fine for the SSA, or UPS, where you have tracking number as well, some way where you can track it, and then you can keep in that box the proof that they received it. Not only just that you sent it, so you do want to keep your receipt, but that they received it. Because then when they say we don't have nothing, you could say, yes, you do. And then when you have to reapply because they don't have your stuff, you can have an argument to say, but you need to use my old application date. I'm just resending you stuff because you lost it, but I had applied. Okay, so once everything's perfectly done there, and that's a lot of little fingers probably in the pot, they don't make the decision on whether you are disabled or not, okay? They are just intake. It's very narrow knowledge base for that. Once they have everything and they know that all the technicalities are met with all the paperwork, then they send it up to the state agency, which basically it's an outsourced area within our state, whatever state you're in. Sometimes it's some sort of health department. Sometimes it's even the education department. I've seen they have a thing for disability determination services. So it can really vary. But once it gets there, you're generally going to be contacted by that office that has usually it's in a different town, but not necessarily. I know one of the towns in my town has both their own field office and they happen to house the DDS. That would be Wilkes-Barre. So once it's there is when they start to do the medical workup. Prior to that, none of that's done. So you're going to expect to receive something called a function report that they're going to want you to fill out. Now, I have a ton of videos on the function report because invariably, 99% invariably, people really blow it. They're not responsive, or if they are, they're not responsive, and then being not responsive, they say things that are irrelevant but harmful because they don't word things in a way that's really clear. They're just not being careful how they're explaining things. So as disabled as they are, it's not going to come off that way. I would really urge you to look at the function report videos. I happen to do a bunch of them by number. So like some of the big ones, 5, 6, 12, 20, big ones that take a lot of thought. I would go through those because you are going to blow it, or you're not going to give what would be helpful later at hearing for an award. Okay. I always say the opinion I have that you're not going to win on your function report, but you can lose on your function report. So you can sink your ship with it. Although it's never going to carry you if your medical records don't, but it can sink you even if you have decent medical records. So function report, very important. They're also probably going to send you a work history report. The times when they don't send this is when you had one job in the 15-year relevant period. So we're talking about the past relevant work, which is a 15-year period prior to the date you are applying. I have a video on that explains that a little better in more detail. But if you had more than one job, you're going to get this work history report. It's the SSA 3369 if you want to look it up. That's not a bad idea, by the way. Getting these documents from the internet, from the SSA.gov site, look up SSA-3369, and you can work on these in advance. So when they demand it from you and you have one day to get it in, you already have it done. That's what I would do. If I didn't have a lawyer who's already working on it with me. The function report is SSA 3373. I would download that one too and get a head start on it. There is also something that frequently goes out, maybe not 100% of the time, but most likely the SSA 3380. And that is the third-party report, third-party function report adult. So it is for an adult that you know. It could be a spouse, family member, friend, someone who knows you well. And they're basically going to answer the same questions that you are answering on your function report, but it's coming from them, not from you. So leave that alone there. But you can give them a little heads up. If you're going to give it to them in advance, that's probably the person that you're going to also put down as who can we contact, which will be in your application previously. So knowing that now, put the person down that you would prefer they be answering those kind of questions. Yeah, so we've function report, work history report, adult third-party function report. Sometimes there's a proprietary additional reports. And I say proprietary because it's not really one of the ones that are generally used everywhere, like the ones I just mentioned, but a particular office might have their own little cute one they want from you. Sometimes it's called a pain questionnaire. I've seen headache questionnaire. So if you alluded to those kind of things, they might send you one of those. They're not as common, but some offices do it. Pain questionnaire, headache questionnaire, seizure. I've seen seizure recently too with one of my seizure clients. So you can't really plan those in advance because you're not going to be able to, you're probably not going to find the exact one they send you online, but just be prepared that you might get that. And you do generally want to get them in before the deadline. If you have trouble getting it in, because let's say they give you a 10-day deadline and you got it on day 9, you know, you really don't want to rush these reports. I see people that barely answer them because they just don't feel like it. It's inconvenient. It could be because they're in pain, exhausted, fatigued, whatever. You don't want that to be what you send in. You just don't. So I would really suggest that you work on those and plan to have them completed and ready to go maybe a week before, or within a week after you file, because they're popping these things out sometimes very quickly. It used to be we had months, and now the whole time frame has changed. So I really suggest getting those done where you have the time to do it at your own rate. You could even get them done before you file your application, but make sure that when you're filing your application, you're not letting anything scroll, any of those old months scroll off the board. So if your alleged onset date is more than is breathing down the throat of 17 months, get that protective filing date, of course, even if you're not ready to send in your whole application, and take that from there. Yeah, I got the sun in my eyes. It's just lovely. Maybe I'll turn. Oh, that's not helping. Okay. Well, that's a little better. Okay, so we got this. You're going to potentially get phone calls from the adjudicator. This is why, another reason I do not like I don't like it when people are pro se. And it's not just because I'm biased about, this is the business I'm in, although that's true. Sometimes the adjudicator will make a phone call and ask a seemingly innocent question, but it can be the answer that you give, if you don't understand it, and how you give it without further explanation can also sink your ship. And they're not going to explain that to you. There was a recent situation where an adjudicator called my client, and that's a no-no. I don't allow that. And they're told right from the get-go that they go through me. My client hired me for a reason. They do not need to have the stress of having this person on the phone asking them questions about their health. When we talk, and I will relate it to them, and I'll put it in a certified statement if they wish, but I don't want them talking to my people. So the person said, oh, you have a hearing problem. Well, does it prevent you from working? Now, does it prevent the person from working? That is a legal question with a legal conclusion that I can't even believe was asked of the client. Completely, in my opinion, inappropriate, aside from the fact that she was circumventing the lawyer, and that shouldn't be happening. So, and the reason why it's inappropriate, any question like that, does it stop you from working? Well, geez, does not hearing well stop me from every job in the universe? Probably not, because not all jobs require astute hearing. But does it carve out any jobs? Absolutely. And that's the only answer that's relevant. So that was really inappropriate. Of course, the person was caught off guard, didn't know what to do, and then maybe thought this person's trying to help me and said, well, no, I didn't lose my job because of that. And that's true. But that wasn't the question. The question was, does it stop you from working? And now the person's saying, well, no, it doesn't stop me from working. I think the way they put it was, does it preclude employment? Does it preclude you from working? Well, no, being hard of hearing doesn't preclude all work. But if it precludes some, it could end up being an award for her. So by having her try to get from the client no, it didn't stop me from working, because she's just thinking about her old job. It's not the thing that got her, unable to do her job. She now has a yes. And now this adjudicator can, will, I don't think it's appropriate, but will feel more comfortable denying the case without going further. So of course I had to intervene and make sure that didn't happen. But so this is why not to get off topic, but I prefer, for your sake, that you have someone who is that go-between. And if you have a lawyer who says, no, you answer all the calls and you talk to them, I don't want to talk to them, that's weird to me. Just saying. But if they do call and ask you questions, you kind of then have to, if you don't have a lawyer to direct them to, you're going to have to answer. But just know that it's a very, if you don't know what that question means and what the results mean, you might answer it wrong, like my person did. And then I had to set the adjudicator straight. So, and by the way, it's called an adjudicator or an examiner. Some places it's called a claims rep. So depending on your jurisdiction, is the person that's handling your case at the state level where they're doing all that medical workup. So part of that medical workup is they're going to be ordering the records of the providers that you told them about in your application. Okay. And if you forgot somebody, that can happen, right? You need to communicate that information to the adjudicator. Now, hopefully the adjudicator or examiner has sent you a letter saying, hey, I'm working on your case. And then you're going to have the phone number and probably the extension for that person. You might always get a voicemail, but at least you have a place to leave messages. Ideally, they also send you a barcode so that you can fax documents in. That could be medical records, although I tread carefully there for other reasons. If you have a new provider, I would put it in writing and fax it to that number with the barcode. I would do that instead of, or in addition to leaving a voicemail, only because now it is scanned into the system and I don't think it can be readily removed. So there's always going to be proof that you told them about this medical provider, so they can't say we were never told. And then their duty is to actually order those records. If you had a full and complete copy of the official record set, yeah, you could send it in. But a lot of times I've seen in the past people sending in a few of the visit dates of Dr. Jones, because they're thinking I'm helping my case, I'm sending in these records, but it's actually stabbing yourself in the foot, I think, because I've seen at the DDS where they're like, oh, Dr. Jones records are here, I don't have to order them now. Part of Dr. Jones records are in, and not necessarily all of them. So the second you kind of like do a little help, everyone stands back and says, ooh, don't have to do anything. So I don't like that. Later on, if you were to get denied and we're on reconsideration and you want to, first of all, I'll get to that point, but if you do get to that point, you want to get a copy of your file so you know what they had. The letter of denial will have a couple of things. This is what we looked at. This is what we got. We didn't get anything else. It's a little vague. You can't really tell what was in the records that they got, even though they got them from Dr. Jones. So, story for another day. But so that DDS agency, State Department, with the examiner or the adjudicator, will be, in theory, ordering all of your records, and they're pretty good at doing that. Some of them they can get kind of automated. We call that a HITMER. And that's usually from big health networks that have some sort of agreement with the SSA that they can do this. Other times they have to send out your signed 827 that you submitted when you applied, and they get them that way. If your doctor does not provide the records within 2 to 3 weeks, I think it is, maybe 20 days, we're supposed to send out another request to like try to light a match under them. I haven't seen this lately, but up until a couple years ago, they would also send a letter to the claimant and us saying, hey, we're still trying to get it from Dr. Jones. Can you contact him? And that was a great little piece of information. Now, at the same time, lawyers and non-attorney reps who are connected with the SSA can get in and see what medical records have been received of the ones we told them to order or that we submitted. So we kind of don't necessarily need that little heads up, but for all of you pro se claimants, you can't get in there. So you're not going to have a clue if your medical records aren't in there until it's too late. So just giving you the heads up. If you're not If you can't get into your electronic file, you're not going to know. I don't know if they're putting that in people's personal SSA files now. I don't think so. It'd be nice though, right? Anyway, okay, so they're going to do the records collection, collecting your function report, collecting your work history report if relevant. They could contact you about more details about your work history. Work history report is so important not to screw it up, particularly if you're over 50 people. But if you screw it up when you're under 50 and then you have to reapply again later, that old one might come and bite you in the butt. So I really, really, really think you should learn the meaning behind certain things before you go and flippantly fill it out. But anyway, if you're on your own, this is what you have to do. Medical records come in, all that stuff come in. Usually by the time they get the medical records, they decide whether they can award you at that time or not. As you know, the vast majority do not get awarded at that stage, but some do. If they don't, sometimes, very often, in fact, and it might vary on jurisdiction, they will refer you to one of their consultative examining doctors. There's probably a video too on that. It's not necessarily highly regarded. Sometimes they're helpful. Usually they're not, but sometimes they are. I've seen some decent ones. You kind of have to go when they do that, because when they're doing it, they're saying, we can't award you based on what we have that you told us to get. So we need a little more information to decide whether we can or we still can't. So it does kind of give you a little opportunity that maybe you can, but it also can mean they're just not going to be able to award you one way or the other. And then you would get, usually it's very shortly after that consultative examination, by the way, that you generally go to in person, that they're going to make a decision. So what happens is, behind the scenes, a medical expert on their side that actually never treats you or meets you reviews all the records in it that's in there and evaluates that evidence to decide, do you meet a listing? Do you not meet a listing? Most people do not. Even people that win at that stage do not normally meet a listing. If you don't meet a listing, what is your residual functional capacity left to do work? When we see you have impairments, do you have severe impairments? She figures out which ones are severe, which ones are non-severe. And then how you are limited in all the relevant functional areas that the SSA relies on. That'd be sitting, standing, walking, pushing, pulling, lifting, carrying, mental skills as well. Are there any mental limitations to concentration, persistence, pace, interacting with others, being able to get along, keep attendance, that kind of thing. They will decide what the medical evidence on paper shows about you, in their opinion, and they will quantify you, so to speak, in a residual functional capacity assessment. Okay. And that assessment is what is ultimately going to decide whether or not you are disabled or not. It's very kind of cut and dry at that point. And then you get your letter, yay or nay. And after that letter, you have 60 days. You have to read your letters, by the way, everyone all the way through. Just do it. You have to, whether you have to do a line a day or, because you have deadlines that you're going to have to respond to. If you get a denial letter, again, you're going to save that and put it in that box like you did everything else. But that's going to be telling you that you have 60 days to appeal for reconsideration. I think most states are still doing the reconsideration. And you can do that appeal online, and it tells you the address. If you do not have access to online, you can do a paper appeal, and it should tell you how to do that as well. If you have any questions, I would call that field office and see if they could send you very expeditiously what you need to fill out. But again, mail being what it is, and they only use U.S. Postal Service, you might find that to be insufficient. So online appeal, generally the way to go. And the online appeal is going to ask you basically what's changed. First, it's going to ask you, has your condition changed? Has it worsened or improved? Very rarely does someone improve, I'd say. That it could be if you had a surgery that fixed an acute problem and you're going to be much better. But then you have to also recognize that if you were denied before on how bad you were before and now you've improved, you're probably going to definitely be denied on reconsideration. Okay. So you need to look at every body part, think long and hard about, are you able to be as active as you were? Even though your activity was limited before, is it more limited now? Because has the pain become more prevalent? Is the duration of how active you can be shortened? Do you have to lie down more, sit more, rest more? That kind of thing. Maybe you're not driving now. Whatever the case may be, you're going to want to describe how worse you are. All right. Your condition, like your ability to do things. And then the next question is, are there any new conditions? And that's where, if you do have a new diagnosis, or if you're not diagnosed yet, but you have a new body part that's causing you problems that you didn't mention before, I would toss it in there. Okay. You might not have a diagnosis yet, but if you toss it in there, which you should, you need to go get it worked up. You need to go get treatment for that, because otherwise they can't consider what you say. You're not the medical doctor, so you can't even diagnose yourself. It's got to show up in the medical records. So that's when hightail it back to the doctor. You should be aggressively treating this entire time for every big and small impairment. I have a video on how so important it is to not limit your treatment or your following with a provider or a specialist to only the few big bad things. So check that out. Super, super important. That's what probably shoots most people in the foot. Okay, so Recon goes out. Oh, with the Recon, it's going to ask you for all the providers that you have seen since you last reported to them. And when they say reporting, I wouldn't presume it's the things that you told them about in the interim afterwards, like, oh, I forgot to talk to Jim. Anything that wasn't in your application. And remember, I told you to print out your review summary of your application before you submit it, so you have a problem of what you submitted. So go in your box, find out that list that you gave them, and anyone that you have seen, even if they're on that list, but you've seen them since the date you sent that in, any of those guys and any new ones, you're going to re-put those all in. Address, phone. They ask for exact dates. When did you first start seeing? When was your last date? And when's your next appointment? Do your best there. But if you don't know, just say approximately so-and-so. Don't forget, and this would be on your application too, I see people leaving out hospitals all the time. Like, well, yeah, I went to the ER on the date, but I guess they don't consider them their treating doctors. You definitely want that in there. Any ER visits, urgent care visits, even though that's not like your regular doctor or your regular specialist, hospital visits, admissions, anything. Give them their own page, put them in there, okay? One hospital, you can have multiple times you're at the ER. And if you're at the ER more than, say, the 3 spaces they give you, and I'm not sure how much it is, it might be 3, put it in remarks. Don't leave anything out, all right? And here's another tip. If you're not sure of the first date, last date, you can estimate, but err on the side of caution. Go wide, okay? Or go deep, depending on how you look at it. If you're like, well, I can't remember if I saw him from 2020 or 2019. Say estimated 2019. That way, when they order the records, they're going to ask from 19 and forward and not 20 and forward. If they ask for 20 and forward, guess what's not coming in? What was going on in 2019? So give them the broader area. Don't go too crazy like 2010 if you know it was 2019, because now you're going to lose a bit of credibility. But definitely err on the side of caution so that more records, not less, is going to be put in there. You don't want anything left out. You never want to leave out any doctors for any reason, okay? Mental health, even if you didn't file on it, you're going to want to include any mental health treatment. Current treatment is so, so important, particularly for the over 50 crowd. So if you're getting therapy, don't be shy. You want to put that in there, okay? Or if you're on medications management, or if your primary care is giving you, prescribing you mental health prescriptions, say for anxiety or depression, you want to make sure that is clear and in there. And of course, the better advice most likely is that you should be having that addressed by a mental health professional and not your family doctor for evidentiary weight purposes. There's going to be details of a mental health nature in the records that you're not going to see with a primary care provider who's just writing you scripts, okay? Very, very, very important for case strength. I can't emphasize that more. So when you get that recon all done and you submit it, again, keep a copy before you submit of that review page that you're supposed to review before you submit. Print that out. I can't emphasize more, particularly if you think you're ever going to get a lawyer to jump on board. You should have already had one, but if you're now at this stage, boom, right away, do it. And you're going to want to have that paperwork to show him. So he has something to build upon without having to wait 3 months for the SSA to connect all the dots and get him on board, or her. And by then, now you're breathing down the throat of an ALJ hearing, and he's not going to have time to give you the advice that you're going to need. Okay. Because a lot of the stuff the lawyer is going to do is give you advice that had the things that only you can do to strengthen your case, that will then help him create the arguments and the briefs and connect all the laws with what your new great evidence is. Okay. That's our job. Your job, however, is to follow that advice of getting diagnostics, some specific specialty treatment, perhaps, and certainly follow up. Okay, so reconsideration is done. Now you go to reconsideration. It used to be the only thing that occurred was that the examiner at that stage now ordered all the updates that you told them about, which is why you don't want to leave anyone out, even if you saw them before, as long as you saw them again. Now, though, seems to be post-COVID, I think, because things are taking so long on initial and recon that they know a lot may have changed. They do ask you for another function report. So I would look at your old one, which you kept a copy of before you sent it to the SSA, right? And I would use it as a guide. Okay, this is what I talked about before. Which one of these things are worse? And use it as your baseline, so that things that became worse, you are describing them as worse. You'd be surprised how it can really vary, because people forget how they were feeling back then. And now their second one, I know they're worse, but they don't sound worse. So take your guidance from your former one, redo into a new one. Again, look at those function report videos. I'm probably going to come out with one big, long one so that you don't have to look at different videos, but it's going to be really long. And the reason why I did them in terms of here's number 5, here's number 6, question number 20, was so that, people didn't get so bombarded with one big, long video. But if you're the type that likes to do your function report and sit down and pause and and go through it all like that, that's why I'm going to put that out. Because that's everyone works in a different manner when it comes to going over the guides and the tips, right? So we'll do a big long one too. All right, so now you're in recon. They're probably going to send you a function report request, which again is something new. You'll get that in. They may or may not send you for a consultative examination. I'd say they often do not. If you had some new big bad impairment that you reported on, they might, but generally I don't think they really want to spend the money on more than one. I should add that sometimes when they send you to a consultative examination, if it's a physical problem, particularly if it's musculoskeletal, they might send you for x-rays too. They don't tend to pay for MRIs, unfortunately. If you have a hearing problem and you don't have a hearing test in there, they might send you for a hearing test. I've seen that frequently. Okay, so recon. Now it's the waiting game again. You're going to continue. While you're waiting, you are continuing to aggressively go to specialists for everything that remotely even has a specialist, I would say. Really, really be proactive on your own behalf in terms of getting that evaluation, treatment, follow-up. Okay. And then, and being very vocal to your doctors about your ongoing complaints. And when you do go to something new or have something big happen, whether it's a new provider or a new diagnostic or let's say it's physical therapy or some sort of procedure, I would reach out to the adjudicator. Again, I like to have that done in writing, where who did the new thing, when it was done, or if it's a new provider, when do you start treating, still treating. If there's a new diagnosis, an official diagnosis from your doctor, do that in writing, put it on that barcode. If you need to call the adjudicator to get a barcode, do it. Just say, I need a barcode to get this to you by fax, because that's how I usually like it. Getting everything in, and they're going to come out with another result. Sometimes we refer to reconsideration as the rubber stamp stage, but it isn't always. I mean, we do get them overturned on reconsideration if we have someone who really follows directions, and by then they've had enough time to actually follow our directions in terms of, you really should get a specialist for this. Because you know how making an appointment, it can take 5 months to get an appointment with a specialist. Ouch. Now you're like done with initial, potentially, well into recon. Now there's only one visit. So if you can at least get that far, that'll set you up. So if you have to go to hearing, which is most likely, you now will have all that piling in now. So you have to have time to get that advice and follow it. Okay. And it's all advice from an evidentiary standpoint, not from a medical, you need this medically, because we're not doctors, most of us anyway. What else? Okay, so recon's over, you get your decision. If your decision is denied, you again have 60 days to appeal. And that would be for the ALJ hearing finally. They're also going to ask you if you would do a video hearing or a phone hearing. I'm not a big fan of phone hearings. For the majority, there are some exceptions. It's fine. The video hearings, I have to say, have been really, really well taken. I never thought I would think so. I think they're actually potentially better than the in-persons. Won't go into why, but I do. So if you, unless you're really adamant about in person, and you might have a good reason for that, I feel comfortable with the video hearing in current day. But then again, we've done a lot of work on the case all along, so that could make the difference. So anyway, totally your decision, in person, phone, or video. Video or phone will probably come the fastest if you're looking to have a quicker hearing. If you're maybe needing more time because you realize you dropped a ball on some sort of medical evidence that you should have been getting, you might want to go with in person. Just a strategic thing there. And then you get ready for that hearing. I would, I don't know how you are at preparing for hearing from a legal standpoint and making your arguments and tying things together, and what evidence you could be getting that would be persuasive to a judge, because he has a little more discretion and, dare I say, knowledge than those below. So you have a whole new bite at the apple. He doesn't have to follow what they said. Okay. So, and he'll tell you that, he or she will tell you that at the hearing. But that is where you're heading to next. And at your hearing, very often there's a vocational expert. I would expect one. Sometimes there's a medical expert also. That's less often. So it will be you, the judge, your vocational expert, if there is one. And I haven't been to one without one in years. And the court, I'm going to call her the court reporter, but she's recording the audio of the video hearing, or the audio of the in-person hearing, if that's what you do, or the audio of the phone hearing. She connects everybody in. If you do agree to a video hearing, you're going to get an email. And they've been sending them out pretty early. So if you don't get it like a week before your hearing, I would contact the OHO, Office of Hearings Operations. It's at the top of your hearing notice, upper right-hand corner, and call and say, I haven't gotten the email link to the video hearing, because it's going to be MS Teams, and you will be on the morning of the hearing. I usually suggest doing this half hour beforehand. Make sure your link works, clicking in, making sure you're connected. It's going to say the hearing hasn't started, but we'll tell them when you're here. But then you'll see, where you can have your little, make sure your video camera's on at the time, or off if you're waiting for the hearing. So you're not that anyone's in there and they're not videotaping you. It's only audio. So, but you could have your mute on or whatever. And then when the time comes, you're going to have to remember to unmute yourself. Okay. What else? At your hearing, the basic areas where the judge is going to go into, by and large, it's what your prior work was. This is very nutshell. And then your activities of daily living, to see what you're still doing and able to do in a non-work environment, to kind of reflects on what you might be able to do work-wise. Are you still shopping for yourself? Are you still cleaning your house? How often do you go on vacation? What are your hobbies? A lot of the stuff from your function report, you could probably make sure you have your knowledge of what you do with regard to those things, because that's kind of where they come from. They can throw in a couple things. If the judge sees something funky from your medical records, let's say it says you went scuba diving or mountain climbing and you have a bad back, he's probably going to ask you about it. It's not going to be good for your case. Got to tell you that. If there's reference to you having worked, or is your doctor, you told the doctor you were doing some part-time work and you haven't reported it to the SSA and your adjudicator and your judge, and they will have sent you a request for information about any work. So if you've been doing that, and it often shows up through the medical records, you'd be very surprised. You're going to want to make sure that you are coming forward with that information. The big areas: prior work and activities of daily living. And then all these little peripherals I'm talking about now, like if something shows up in your medical record, it could be a legal problem showing up. It could be you went to a rehab for drugs. Those are the kind of things they might want to pull out because they can have relevancy to whether they can award you or not. Okay. So you want to be very frank. If he asks you, it's for a reason. It's probably because he or she saw in your records something to that effect. So you want to be very frank and transparent. Okay. And of course, if you have had a problem, you want hopefully to be able to show that you have made effort to be straight and sober for some time, if that was the problem. It could be a variety of things. Get very clear on, if you did work for a few months trying to make ends meet, be very clear on start date, end date, and how much you made. And if you have those pay stubs, I would get them, even at this stage, because the judge is going to have to determine if you worked too much in the interim to interrupt the disability process as a matter of law. You want to be able to find out what the law is on how long you could have potentially had an unsuccessful work attempt and when it would no longer be considered that. So you kind of have to do some of that legal research if you want to do the best job for yourself. So, if you can, that's what you're going to want to do. If not, you're just going to have to wing it and just be as transparent as possible with the judge and hope that anything you've done hasn't put a fork in your case. But anyway, judge is hearing. The judge will have the vocational expert. He will ask the vocational expert after you've testified to everything if he can quantify your past work. So then they have like a categorization for that. Then he's going to ask him a hypothetical, one or more hypotheticals about a hypothetical person, not you at this point, with a certain residual functional capacity that the judge thinks might be something he's going to determine matches you. And are there any jobs that hypothetical person can do? If the VE says yes, he could do X, Y, and Z jobs, that hypothetical person. The judge may leave it at that, or he may continue on to give another hypothetical that is even more limiting of the hypothetical person. He might, make it less able to lift as much, less able to be on your feet, which they would be categorizing as sedentary or light or medium or heavy. So there's terms of art, again, that if you don't know what they mean, you're not going to understand what that means. And eventually, he may get to a hypothetical where the vocational expert says there are no jobs that hypothetical person can do. When that happens, generally the hearing comes to an end and the judge thanks you and tells you, usually, not always, but usually, that he's going to go over all the evidence and then render a decision in writing. It could take, anywhere from, I've seen a week on the shortest. That was recently. That was fabulous because I had a fabulous result too. I've seen 6 months. Usually it's a couple months though, but you just never know how staffing is and shortage of labor and all that. Things can take longer. So you're not necessarily going to know the result. You're probably not going to know the result of your hearing until you get that decision. All right. Unless the judge flat out tells you, I'm awarding you. And that's a wonderful thing. Okay. When you get the decision, if it is what you want, and you want to read it carefully, because you can have an award that's fully favorable or partially favorable. If it's partially favorable, that usually means the judge found you disabled, but not as of the day that you claimed, that at some later date. And then you have to decide whether you're going to appeal that finding. And there are things to think about when you do that. So I wouldn't just do that, without a lot of thought. That sounds really bothersome. If you want to appeal, let's say you get a denial and you want to appeal. The next step is the appeals counsel. The appeals counsel does not accept new evidence It's got to be, well, that's a term of art too. You can't just go to the doctor now and send it to the appeals council. The appeals council is looking at what your judge had, because they're basically making a judgment as to whether or not the judge erred under the law of what he or she had to do before rendering a decision. So that obviously depends on what you had given the judge to consider. Okay, so you can't go and throw in new stuff now. There are times you might be able to get in old evidence that was missing during the relevant period, but you're going to have to show why you didn't have that in at the time. And it's going to have to be for good reason, probably. So the AC Appeals Council does not have to necessarily consider it, and often will not. If you do that appeal, that's very easy, by the way. If you have to appeal to the Appeals Council, it is very simple to get that appeal in. You can do it right online. You have the 60 days like you did for the other ones. You can even ask for they usually give a 25-day extension if you have something that you think that they can legally consider, including a legal brief. If you're not going to do a legal brief because you really have no clue what you're doing, you wouldn't ask for the extension. You want them to start reviewing it right away. They have an obligation to review your whole case for you. It can take, there's no real deadline, I don't think. I've seen a month, I've seen 18 months. So it could be sitting at that level for quite some time. You're not going to hear a thing except for the fact that they got your appeal. Okay, generally there's nothing that's going to be after that until they make a decision whether to review or not. Vast majority of the time, they're not overturning. They're going to say, we decline to review because we don't see that the judge did anything wrong. So in that case, your next step, if you're going to appeal, is to find a federal district court attorney that does Social Security cases and takes them to federal court. Those are much slimmer to find, and they're very particular. They're not going to just take your case and work for free on a case they don't think there's an appealable issue. So when you look for one, and there's a few big names out there that they're very helpful, they'll look at it and they might not take it, but at least you had them look at it to see if it was worthwhile to take. You're going to want to have your ALJ denial letter, right? The decision, technically, and your appeals council decision. And if there were any briefs submitted before your ALJ hearing or your appeals that went in with your appeals council review, I would submit those too. And then the federal district court attorney will make a decision as to whether they're going to accept your case. You need to find them right away. I would say find where you're going to send it now. Like always have that in your back pocket of who you know you're going to send it to. Have a few of them, and that way, the second you get the denial, you can ask them for the help, because they only have, I believe it's 60 days also, and they need time to review and decide whether they're going to take it and get your stuff. So, and get your signed documents retaining them. And again, they work at no expense to you. So they're going to be very particular. They're not going to take a loser case. No offense. It doesn't mean they don't think you're disabled. It just means that they don't see anything that the judge did that he wasn't permitted to do, because the judge has a lot of discretion on whether to find you disabled, but he does have to look at everything, and he has to give a certain flow of consideration, some legal steps to doing that, which he explained in his decision. But sometimes they do forget something. There could be a big impairment that was clearly diagnosed and it just was completely left off of the decision. That would be a very appealable issue. So let's say you can't get, let's say we're going back to the ALJ and you got denied and you're like, well, I definitely want to appeal the appeals council, but I really want to file again because I still have, I'm still disabled and I need to eat. Okay, that gets a little complicated. I probably shouldn't even go into it here, but maybe I will just touch on it. After the ALJ hearing, you cannot appeal to the appeals council for the same disability benefit on the same impairments that if you're going to refile for a new period. So if you do appeals council, you cannot file anew for the same disability benefit. So that would mean if it was a Title II, meaning Social Security disability benefit application that you are appealing to the appeals council, you can't then generally, there can be some rare exceptions, you can't now generally go file for a new Social Security disability claim. Okay, you have to wait it out with the appeals council. And then when you do, you may or may not be able to You will be able to file again if you still have a window of insured status. Look about our DLI videos, date last insured. If your date last insured is before your ALJ denial, if you already ran out of your window, because maybe you filed late or it's already your third application, whatever the case may be, because you may have had 5 years or less of a window, you have no choice if you want to keep it a chance of it being alive, but to file an appeal to the Appeals Council. If you do have a window left, your date last insured is not till the future, or at least some date after the ALJ decision, and you think you have some really good evidence after that decision that came in, you will be able to file again. But you need to know these things. You need to know that DLI. You need to match it with whatever the ALJ's decision is, because your only remaining avenue might be AC appeal. And assuming you get denied on that, like most do, you still then can go to the federal district court. But you need to know, right? You need to know. So as soon as you get the ALJ decision, you'll know. You should go to find out if you still have any more ability to even file anew. And then you decide, am I going to file anew now? Or am I going to like wait a while because I want the Appeals Council to look at this first? So going back to the Appeals Council, if the Appeals Council granted you instead of denied you, or then you wanted to go to AC appeal, if they granted you, they most often remand you back to the judge that denied you and said, Judge, redo this hearing because you forgot to do XYZ that you are legally obligated to do. Once in a blue moon, they actually reverse the whole thing and award you. That's rarer though. If you decide not to go to the Appeals Council because you decide, you know what, I just want to file again. I have plenty of window or plenty of new evidence, or now I have insurance and I can go balls to the wall with treatment that I couldn't do with the case before the ALJ, whatever the case may be. You can file anew for sure if you don't go to Appeals Council. If you do go to the Appeals Council, you might have to wait. There are some exceptions. I'm not going to go into them fully here. If you go to the Appeals Council on a Title II Social Security disability claim, you can file an SSI claim at the same time because they cover different periods. And they are different disability benefits. So you probably can file for SSI if you're, within that poorer range financially, but you might not be able to do the Title II SSD while it's at Appeals Council. A lot of little intricacies there. So I'm just giving you kind of some basics, and that's not going to be all encompassing. So don't write home on that. But just know that those issues exist. If you're done with AC and you're going to federal district court, regardless, you can file anew now if you still have that window open for Title II Social Security disability, or if you think you're eligible for SSI. Now you can. No holds bar, that AC doesn't block you anymore, and the federal district court doesn't block you. So you can file, and you should. If you are going to federal district court, in my opinion, I can't even think of an exception, although there might be, and you have an opportunity to file anew, you have validity in that, do it at the same time. You more than can. You can file you can do your federal district court appeal and start a whole new case. And the whole new case, the alleged onset date would be the day after the last official denial, which is the ALJ's denial, not the Appeals Council. Okay. So you would say, if the judge denied you on April 1st, 2022, you can always allege the old date that you did before, but for technical reasons, they're going to give it the date of the day after the ALJ's decision because he already decided you weren't disabled at any date prior. But either way, they'll figure out that technicality. You don't have to, but for all intents and purposes, it's probably going to be the day after. And you can run with that whole case. And then if the federal district court remands it and agrees that the judge did something wrong, even though the AC didn't find it, they will merge your new case for the current time and forward with the old case that the guy screwed up on. So potentially you can win the whole kit and caboodle, whole 9 yards. Okay. I think that's the end of this little longer than usual video, because I usually keep them real short, but I wanted to get that whole thing in so you know from the time you start to the time you end where you're going. And remember to always look to see if you can file again if you get denied at any stage, but always know your date last insured. And you can find that by calling. It's going to be in your ALJ denial if you get that far. If you're not even that far yet, let's say you're still back on initial or reconsideration, you can consider calling the 800 number, 1-800-772-1213. It's a menu-driven national number, and you have to hit the menu items, but you want to get to a live body. And when you do, you want to ask for your date, last insured, DLI. That pertains to Social Security disability and not SSI, but find it out for both. Okay. If you file for Social Security disability and you do think that you are very poor because you don't have a lot of money in the bank, you have less than a few thousand, and you don't have, income to speak of, or very little, always consider filing for SSI when you file for SSD. Don't leave out the SSI application, even if it's not going to fly in the long run. The medical workup is the same. You're not going to be doing any additional work except filling out the SSI application with the very simple financial stuff they ask for. What's your income? Are you getting that? So consider doing that, because I do see people that fail to file for the SSI, and the SSA doesn't really tell them that they can or should. And then when they win, they find out they didn't have SSI and they couldn't win on the SSD, and now they've got nothing. So when you're filing pro se, definitely, or with an attorney, definitely make sure you've taken a hard look at if there's a remote possibility that you could get some SSI, even if it's for just the 5-month waiting period for the SSD win. And that's in a different video if you're not familiar with that. That could be $4,000 or $5,000 in your pocket that you wouldn't otherwise have if you win. That could literally pay for your attorney. Anyway, I hope that helps. Just give you the big rundown from beginning to end. Yeah, we have shorter videos on all the different areas in a little more detail, but that gives you the big picture. Okay, I hope it helps. Have a great one. And you know where to reach me, Stephanie Joy at Joy Disability. If you ever need to have your case reviewed for representation, I am happy to do that. All right, take care. Bye.